part of East African community, so I don't know that one where it came from, but I think even in village once you say I'm from Kenya or Tanzania, they know. It's good you have talked about the conduct today, and you remember it was raised the other time, and I said I'm going to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court, to the extent of even of standing on the chairs which are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere. Once a council or anybody submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where confliction come from if we are following what we are supposed to do. Unless, if you have, especially Council Pago is asking about my road versus chairman, and then the reserve members.
I think, sir, I will take the opportunity to respond to the legal issues arising from the submissions of the defense lawyers. And I will also refer them to read carefully Regulation 63, which talks about the duties of the judge advocate. Sub-Regulation 1 says that the prosecutor and the accused respectively are at all times, after the judge advocate is named, to act at the trial, entitled to his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, calling this court a tribunal, that one will not happen. The UPDF Act defines court-martial as a field court-martial, general court-martial, or court-martial field court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintend over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adopt dictionary definitions. Secondly, the issue of Eron Kiiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Sub-Clause D, sometimes I remember to read because when I refer that people read, they say I should read, so I will read. It says every person who is, right, that's a right to a fair hearing, every person who is charged with a criminal offense shall, when you go to D, be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled, However, gravity of the offense, you cannot say that when we have 30 lawyers here, Eron Kiiza, who was convicted by this court, is not there, and therefore the right to a fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. When we started this session, all court members, including those in reserve, were present, and all of the members before you have been following this case, have been in court. So the fact that you are seeing one is not there, whoever is there has been here or from day one when this court started. So you cannot say that these are new members. We have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notes. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Panga, I will not go into it because I have already given my position. But Senior Council Karua say that me, as a Brigadier Tukacungurwa, I called you that you are a foreigner. I have to ask you, if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my responsibility.
May I, Mr. Chairman, remind my learned friend here that it is actually on video. You refer to me as a foreigner. You bring it. And everybody remembers it has caused a lot of heat on social media.
No, bring it. I will apologize. But I never said so.
My question, the court members, we are ready to proceed. This case was
for Eron Kiiza, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court-Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Eron Kiiza when he is in court as an advocate, and the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought you responded.
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
My Lord Chairman, what the senior colleague is referring to, Lord Chairman, I think she will need to address herself on the procedure, especially on references under our rules, Constitutional Court petition and reference rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, my Lord Chairman, I pray that we proceed with what the merits of today's are, instead of going against what the rules of reference provide. I so.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you reopen again. The question of jurisdiction was the first thing we dealt with before I took even a plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg we proceed, Honorable Chair. Maybe Council Kwabo was saying, calling you my lord, Chairman. Nobody has forced you to say my lord. Even if you say Honorable Chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him Honorable Chair of the court. It's okay. So I don't think even it's a question worth asking him that can he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request. Yes, Mr. Chairman.
Council, let's not repeat what have been said and answered.
I'm not going to repeat it, Mr. Chairman.
Yes.
I'm only asking that because we are many, if we could kindly follow a process whereby if a matter is raised before the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding so that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it would appear then that the judge advocate is either coming into the realm of the state and also taking over the role of court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to a conclusion. It would be unfair to Mr. Karibala, for example, if he laid his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Lukwa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, that at the last sitting, your neighbor to my right exactly was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern, and it may go back. So it raises an issue that if we break the consistency of the panel which constitutes the court, then the judge advocate advised that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for the accused persons, that they themselves, no matter the decision of court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, I think it's good that they are here. So that, and I think that's a simple matter. If they say the reserve members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them. I think that will sort out our issue. So I request, Mr. Chair, before, and maybe we first state the issue of the request, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for the time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person can hear
Mr. Chairman, on the same, my whisper has been quoted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was our observation. I think it should be clarified. Secondly, I think my issue of parking includes access. My access as counsel, access in court. I'll be on record. I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as counsel for the accused persons. I'll not carry a box of books like I did today, a kilometer away from here, Mr. Chairman.
I'm sorry, my neighbor is killing me. Says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They allege it is a name or Kalebo, and the collar was red. So we don't know whether the person today has not put the red badge. But my Lord, as you can see, it's a concern that the people hearing us out, when they are changing, there is a concern that we may be we may not be heard fair and squarely. It's our polite request, Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the tribunal, of the panel constituting the court. I'm sorry, of the panel constituting this honorable court. Mr. Chairman.
It's all right, Council. Yes, the other day there was a panel here, as you have said, panel Karibu. But as you heard from Judge Advocate, we are 19 members, when 7 are supposed to be here, including me, and then the reserve is supposed to be behind there also, listening. But maybe some could have misplaced by you. But yeah, you can see too of them there. It's that way in the case one maybe have a problem of fields. Unless you will add on something, but that's how we operate. Then accessing the court, Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And Cabinet?
I think so what I can inform the lawyers is that this court is composed of 7 members before it can conduct business on any case of a capital nature. We have 7. There is now no case arising before this court where Major Sala was not present. So we are ready for today's session, sir.
Language of court. I'm back to you. Afande Besigye. The language of court is English. Now court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I had indicated that I can communicate in English.
A1, English, sir. Mafandola, which language?
English.
And Ra, English. Obeid Lutale, which language?
How did he came to number 2?
So in army, a soldier must follow his fellow soldier.
Wow.
English. Obeid Lutale, English. Afande Besigye and Obeid Lutale, you are lawyers.
Just
back to Captain Ola.
We can provide the list of the panel to your defense lawyers. I think immediate drafts are here.
I think so, without wasting time. You can start, you say, General Freeman Mugabe, chairman. And all other members. If we have reserve, they will also introduce themselves.
Is that what is they are talking about? Brigadier General Robert Freeman Mugabe, Chair General Court Martial.
Major Richard Triawe, I'm a member.
Captain Abdara Wasajawaraga, member.
Warrant Officer 1, Asimu Robert Nyarari, member.
Major Sala Sonko, member.
Lieutenant Colonel Sam Tungura, political commissar, member.
Captain Marion Makindye, member.
Warrant Officer 1, Yard Board member.
Captain Christine Nantumbwe Sayuni, member.
Warrant Officer 1, Yard Board member.
Now, question is back to you, Fantekano. Do you have any objection of any of the members who have introduced themselves?
As the court have more members than have been introduced, because if they do, we want to know all the members of the court. Whether they are here or whether they are not here, so that we can object or not object, since they are interchangeable.
That's right, Colonel. It is Colonel Obeid who have not seen him today, and there is Captain Nekore.
Yeah? I think, sir, on our proceedings, the key issue is that the court is composed of 7 members. We have the members in reserve, they are present, and the court is duly constituted. So we'll go ahead on the next stage of responding to the questions.
assumption then is that the members of the council, as duly established today, and those who discuss, will not change because our clients are objecting or not objecting to the ones who have been requesters, meant that being the constant bank.
Exactly, that is how it will be.
Right? Mr. Chairman,
yes, council, yeah, I have heard that. Yes. RO 127 Form 3, Captain Dennis Ora, male adult Ugandan of sound mind, aged 48 years. Military officer attached to Armored Brigade, a person subject to military law. A2 ROV 0098, Colonel retired Dr. Kizza Besigye, male adult Ugandan of sound mind, aged 67 years, resident of Kasangat Town, Nangabo Sub-County, Nansana Municipality of Obeid District, a person subject to military law by virtue of Section 117, subsection 1G, and HI of the Epidemic Act, Cap 330. A3 Hajj, Obeid Lutale, male adult Ugandan of sound mind, aged 65 years, resident of Mutunde Parish, Makindye Sabagawo, Sub-County, Siro County, Obeid District, a person subject to military law by virtue of Section 117, subsection 1G and H, I of the EPDF Act, Cap 330. A statement of offense on count 1. Offense is relating to security control, Section 128, subsection 1F, the EPDF Act, Cap 330. Particulars of offense. Captain Dennis Ora, Colonel retired Dr. Kizza Besigye, and Hajj Obeid Lutale between February 2023 and November 2024, while in the cities to wit Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala metropolitan in Uganda, held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to prejudice the security of the defense forces. Captain Dennis Ora, have you heard and understood the charge read to you on count 1?
Yes, I have understood.
Do you accept or you don't accept?
My Lord Chairman, I seek your indulgence. First on how to proceed. I've just gotten instructions at the bar to represent Captain Ola. I'm only privy to the amendment now. I humbly request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you please.
How long will that take?
Just a few minutes. About 2 minutes. Much obliged. My Lord Chairman, who may now proceed.
Once again, Captain Dennis Bora, have you had an retired to you on count one?
Yes, I've understood.
Do you accept or don't accept?
I don't accept.
I'm free of not guilty entry.
And I have issues which my lawyers will present to you.
I think that your address on time comes.
Mr. Chairman, we have objection to plea taking grounded on Regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking a plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. That this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Strictness, in Kenya. We have raised that issue before you and called this honorable court martial has not pronounced himself on the matter. So to be a violation of Regulation 23 for the accused person before the knowledge is delivered.
Are you not taking us counsel? Are you not taking us time? It is pre-taking. You can say yes or no. Then we can start from there.
Mr. Chairman, the rule is before pleading to the charge, the accused may offer a plea to the jurisdiction. That is the rule, and this is what I'm quoting. And oftentimes this court martial has reminded us to abide by these rules. And the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate the advice for this honorable court martial. That it's within the accused's right not to take a plea until the ruling is delivered on the judge.
I will remind you, the Council of Kwabo, that the accused himself raised that almost. I'm the one talking. No, I don't know when I'm talking.
Can you listen and finish what he's saying?
You have not raised anything.
You have not heard what that is saying. Now what are you objecting? Without even listening to what he's saying.
I can confidently tell this court and those who are jurisdiction by this court. Just to remind you, you read the ruling and when it was delivered. I will proceed.
Please, hold on. He went to the that one will not stop him from submitting on what
My Lord, presented by prosecutor versus A1, ROV 0098, Colonel Retired Dr. Kizza arrested. A2, Hajj Obeid Lutale, accused persons. Ruling on application made by Council Elias Lukwako.
Ruling raised on the jurisdiction of the court. Not the one of Lukwako. The one of Lukwako is not yet ready.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it, either you go to consult your files. But I know that the ruling was out.
Why are you standing, all of you? No, sit counsel. The first sit. Get that ruling registrar so that we don't waste. We have taken time. That ruling is there.
Nakugambye kateeke wano ng'okateeka eri oli wano.
Why do you insist you want it now? When the court wanted to read it, you didn't want it. Now we are on pre-taking, I mean, the charge you want the ruling.
But you say they read it.
I think, sir, for me, as judge advocate of this court, the registry is even under my office, and I am reading it is here. I have not written it now. So the ruling was pronounced by the court. It is that who raised it himself on here one. So it shouldn't be a point of saying that you are raising it now. What ruled on it?
Oh, most obliged, thank you.
Court have not received the objection. Accused person received the objection. Where is the objection? When was it? My Lord, on 20th November 2024, A1 by then was retired Colonel Dr. Kizza Besigye. He objected to all the court members.
Yeah, I fail to understand. Do you think he's reading what is not written? I thought you were supposed to be orderly and seated.
He objected to all the court panel and jurisdiction. Even A2, who is now A3, raised the same objection. JA guided that the accused have to give reasons for the objections as regards to the court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of military. I believe I should be tried by civilian court. A2 stated the same. JA guided that state had to give a reply to the objections. State replied as follows. It has for my lord. It captures the concerns on jurisdiction.
It's helpful, let him.
Background. State submitted that the object is one. The objection is one, and in reply, they stated as follows: that the enabling law, which is section 117, applies to all the accused persons, that is A1 and A2, as then were referred to. He also proceeded and state and informed court that he did not even know the lawyers that were representing the accused persons. Then JA guided that court had to close for the deliberation and make the ruling. Counsel Kwago submitted that they had no opportunity to meet the accused persons to hear their story and get full instructions. He asserted that lawyers as of practice, they proceed with instructions. He proceeded to tell court that A1, as then was Dr. Kizza Besigye, and his colleague by then members A2.
To those are different issues now. Because for me, I'm always in this court. And what I have is that court adjourned to make the ruling on the objection. Court came and gave the ruling, and I have the ruling here. The court said they are subject to military law under section 117G and H of the UPDF Act. That was the ruling of court.
Mr. Chairman, the judge advocate by law is not a record keeper. He cannot assume the role of the registrar with respect, and therefore the registrar it's under your office, but you cannot, the law does not allow you to come to court and be an advisor as well as a record keeper.
I'm the one who supervises the record.
My lord, the ruling brief is that after 5 minutes deliberation.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons who were. It might be recalled, Mr. Chairman, that when court asked or pointed out to my senior colleague, Mr. Lukwago, why there should be an adjournment, we did point out that we who were present, myself and Mr. Katumba, in the absence of Mr. Kalibala, who were counsel on the record at the time, were not in court when those objections were made. When we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Eron Kiiza of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. When the judge advocate insists that his office has the ruling, which has not been handed down by court, Mr. Chairman, it points to the impartiality of court, and any other person who follows these proceedings on TikTok and whom will only see this caption might think that it is the office of the JA which perhaps writes the rulings for the court. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our land colleague, the judge advocates. Otherwise, it is not a little, it is of much concern, Mr. Chairman, when the registry, which should be the central collection of proceedings for the day, appears to have no ruling. We are pulling rope, and it doesn't appear quite nice, Mr. Chairman. It's my plea and my request, Mr. Chairman.
My lord and members, maybe to make it clear, on the first day, the accused persons were not represented, and that's when they raised the objection of jurisdiction. And on the same day also, Lord Mayor, as then was now his counsel, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background of what happened in court, and then the another one you haven't given us to read it. So I pray to proceed with the one on jurisdiction that was raised by accused persons at the time who were not represented. Citing section 117 of the UPDF Act Cap 330, court ruled that this honorable court had jurisdiction and has jurisdiction over the accused persons since they are all subject to military law by virtue of the same section and ended there. And he proceeded and read the charges to the accused person, to which they all pleaded not guilty. And then that's when Lukwago Elias, with due respect, by then was not counsel, had no instructions, proceeded and also raised some objections as pertaining to the charge sheet. That's what we have.
So I think I have vindicated. Yes, because my report is carrying with the one of registrar. Why are you saying that I'm writing my own things?
That one was finished. Let us proceed.
Mr. Chairman, with your permission.
I was counsel said. I was asking Colonel Kizza SJ, have you had understood the charge read to you in count one?
I have heard and I have responded that I have objections to taking plea on this charge and requested my lawyers present my objections.
You are right, but at this moment I'm asking you, the chosen person, if you don't accept, you say I don't accept. If you accept, you say yes, I accept.
Accept what?
There are two things. If you have had understood, another question is, do you accept or you don't accept?
Accept what?
Your help to you, Mr.
Do I
Chairman.
plead guilty or not guilty? Or you want me to take a plea?
He has invoked Rule 23 that he is objecting to taking plea.
Yes.
And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, Counsel Elias Lukwago to raise the objections on his behalf as he has asked us to do, instructed us to do.
I think, sir, they are taking us backwards. Exactly. That's what the registrar has read. Is the same objection that was overruled. So we cannot go back to where we started before.
Please, no, I'm not allowed anybody now to talk.
Thank you, Mr. Chair.
Because now you are taking us back and it's true. It is a new charge. Now what if just now the one you are pushing for is corrected? Will he accept or he will not accept? So the issue is we have read the charge sheet. It is the chosen person to plead guilty or not to plead guilty, and then you can start from there.
Thank you very much, Mr. Chairman. Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment of criminal charges, and also pointed out to any amendment which can be done which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly, from looking at the amended charge sheet dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, They might be repetitive, but in a dispensation when we are saying it is his right to make the objection. What we request is for court to listen kindly, and then also, as my learned friend has advised, and JA, if we read together Regulation 23, kindly. It says, Mr. Chairman, before pleading to the charge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking a plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because, according to the accused person in the dock, he has asked his lawyer to make the objection. So, my lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear. It is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that to be part of the plea-taking process. Yet the rule requires that before that process begins, he has a right to raise the objection. We humbly pray, Mr. Chairman, that we abide by this regulation. We kindly request, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with the Council FK. You raise your objections, let the state reply.
entertain charges as spelled out.
Violation of Article 23 and 28 of the Constitution of the Republic of Uganda, if you proceeded to entertain this matter. Mr. Chairman, the Constitution confines the jurisdiction of this Honorable Court Martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28:12, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. And also yes, I'm coming to Article 28:7 as well. You read, if I may be permitted to make my case. No person shall be charged with or convicted of a criminal offense which is founded on an act or commission that did not, at the time it took place, constitute a criminal offense. Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, the accused persons are alleged of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28:7 spelled out in the charge sheet, would only constitute offenses in those countries, either in Kenya, in Switzerland, or in Greece. Because, Mr. Chairman, the particulars here, they are talking Colonel Dr. Kizza Besigye, while forces. Mr. Chairman, this one has two limbs. One, because forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of Kenya? They are not defined here. And that is one definition, but also on regulations, particularly regulation 20
22. Regulation 22 provides as follows. An accused may, before pleading to a charge, object to it on the grounds that it's not correct in the law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in the law and that it is not framed in accordance with these regulations. So this is a defective charge sheet. This is our contention. That it's not framed in accordance with the UPJ Act. It's not framed in accordance with the UPJ Act 2005 because it is purporting to bring into the confines of this court, the jurisdictional court, matters which relate to weapons of other countries, defense forces, Brigadier, that is penal defense forces, or elsewhere. Because if it were a charge relating to offenses under the UPJ Act, specifically they will be stated here that contrary to a particular provision which talks about multiple points which are ordinarily a monopoly of the UPJ. But here they are talking to contrary to so the presumption is that court martial has jurisdiction all over the world. That is universal jurisdiction. That whoever is informed in possession of any weapon which is alleged to be a monopoly of defense forces, not for defense forces worldwide, then this honorable has so that offense regulation 22 and the charge sheet becomes effective. It's not correct in law, it's not framed in accordance with the UPJ Act. Then the other limb of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and from here. Mr. Chairman, our contention is that this honorable court-martial has been jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. The consolidated constitutional petition number 55 and 56 of 2011. And this actually was made a number of decisions that have been taken by other countries. First of all, what they have to say, British common law regarding irregular apprehension of one offender abroad and the jurisdiction of
court to try such an offender was examined by the House of Lords in that case of Regina versus Obeid. The earlier approach of the English courts has been that once a suspect is in lawful custody, that suspect and charged with an offense which that court has jurisdiction here, the court has no power and is not concerned with required into the circumstances in which it may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or putting up contrary to the laws of the state of it. That was the and the practice at the and the House of Lords had to pass that position, and this is what it has to say. This is now the common law position